Okay, welcome back. And we have another jam-packed session on also very complex and what I would call hot topics. This hour and 15 minutes, or no, hour and a half that we have, I guess, is going to focus on immigration and EEO affirmative action developments. And I'm going to, again, do injustice to everybody's bio on this panel. So I do encourage everyone to read the bios because this is a very impressive panel. And I'm only going to go through this very quickly. We're going to start off talking about Hire American, policies and the impact on the U.S. labor market. And we have Michael Mandel, who's an immigration attorney from Kauf, McGuire, and Margulis here to talk to us about that. And then we're going to move into developing your affirmative action plans. And we have a few speakers. We have Matthew Thompson, who is at Charles River Associates, who works extensively with attorneys and HR professionals in analyzing labor-related issues. He specializes in the empirical analysis of the ways in which gender, age, race, and ethnic origin are related to employment practices. We also have Timothy Scott, who is a partner in Fisher Phillips, New Orleans and Boston offices. He handles all kinds of employment matters, including representing federal contractors and subcontractors in connection with the development of affirmative action programs and OFCCP compliance reviews. And then we're going to move into using AI to evaluate employment law decisions. And we have Charlotte Alexander from Georgia State University here to talk about employee misclassifications. She is an assistant professor of legal studies in the Department of Risk Management and Insurance at the J. Mac Robinson College of Business with a secondary appointment at the College of Law. And then we have Destiny Dyke, who's going to focus on disparate AI and disparate impact. She just graduated at NYU Law School, congratulations, and will be a law clerk in the litigation practice group of Cleary Gottlieb. Okay, Mark?
Okay, hi everybody. Thanks for having me. I'm going to talk about the immigration aspects of recent Trump policies and how that impacts the U.S. labor market. I'm going to begin very quickly with just a very brief overview on the realities of today's economy and how immigrant workers fit in there. In 1986, President Reagan passed an amnesty, and as part of that, people without legal status were able to gain legal status, and then the employment verification system was put in place. So all employers have to verify the work authorization of all their hires since 1986. And foreign nationals play a huge role in our economy right now, comprising approximately 17% of the workforce, and that's both legal and unauthorized workers, people who are here with the permission of the government and the ability to work, but are from another country, as well as people who are here without the permission of the government, but are, in fact, part of the economy. There have been a number of changes that we've seen under the Trump administration, but in many cases, much, if not most of what is happening is just a continuation of policies that began under President Obama, and in many cases, even before then. Under Obama, one of the top priorities of the government was to try and deport as many foreign nationals in the United States without legal status as they possibly could. President Trump has continued with that and has similar priorities as well. And that manifests in terms of tighter border and interior enforcement rules. The Trump administration has said that if a foreign national is in the United States without legal status, no matter if they're employed, no matter what they're doing, they are a priority for deportation, for being sent out of the country. Well, naturally, that poses tremendous challenges for businesses and for workers as well. When employees have difficulty working, it impacts, themselves, their families, their communities, and of course, their employers. Companies have spent time, money, resources training these workers and supporting them, and when they cannot be here, then crucial work will not get accomplished. These days, the single biggest trend that I can say under the Trump administration when it comes to immigration is that whether a worker is here without permission or whether they are trying to come here legally, everything is harder and more difficult than it has ever been. The specifics might be a little bit unpredictable in terms of how that's happening, but that is the trend. I want to talk briefly about worksite enforcement. This is through ICE, that is Immigration and Customs Enforcement. It's the enforcement arm of the immigration agency, part of the Department of Homeland Security. When Trump took office, his head of ICE announced a goal of increasing worksite operations by 400%. We've already started to see those results come in, and there have been tremendous increases in terms of I-9 investigations, in terms of site visits that are happening. And this is in collaboration with a number of different government agencies. One of the big changes that we've seen from the Obama years, and this is going back to how things were under George W. Bush, are these massive, large-scale raids. Earlier this year, about 100 7-Eleven stores were raided by immigration police. Last month, a meatpacking plant in Tennessee was raided, leading to approximately 100 arrests of foreign national workers. And just this week, a gardening company in Ohio was raided. And when I say raided, it's the massive armed officers, the helicopters flying overhead. And from this family-owned gardening company, approximately 115 foreign nationals were arrested. That was as of earlier this week. And this is something that the administration is saying is going to continue throughout their administration. So to talk specifically about the Buy American, Hire American executive order, one thing that we're seeing with the administration right now, President Trump likes to talk a lot about building a wall on the southern border with Mexico. That's largely symbolic, but we are seeing an invisible wall that the American Immigration Lawyers Association has coined this term to really prevent legal immigration in this country as well. So these are policy changes. None of this has gone through Congress. To really make huge, massive changes to the immigration laws would require an act of Congress. Because Congress does not have the appetite for that right now, what we're seeing are policy changes, executive orders, and Baja Buy American, Hire American from April of last year is the single biggest one. The purpose of the Hire American portion is to protect U.S. workers by creating higher wages and employment rates and protecting their economic interests by rigorously enforcing and administering the U.S. immigration laws. So again, this has had a huge impact on legal immigration. I'm going to talk about a number of these changes that we've seen. Even if they have not been directly attributed to Baja, it is clear that this is inspiring, this is providing cover and justification to the changes that we're seeing in the immigration system. The first is on H-1B visas, and I'm going to cover a lot of ground. I'm going to go through this quickly. I know that we have a lot of panelists here. Happy to talk afterwards about any specific questions that people have. But H-1B visas are for, it's sort of your standard professional visa for highly skilled individuals who are coming to work for a company in the US. These visas specifically were singled out in the executive order as wanting to be reserved for the highest paid and the most skilled workers. That has never been a direct requirement before. It's only been that if people are working in a specialty area, if the employer attests to paying them the appropriate wage, then they've been able to sponsor foreign workers. The result of this is that after many years of increased demand, last year, 2017, and this year have been major drops in terms of the number of applications that have been filed. We're seeing a huge increase in the number of challenges from the immigration agency, 45% from 2016 to 2017. And what this and what so many of these other challenges are designed to do is to try and limit legal immigration into this country without having to go through Congress. H-4 work authorization is another way that we've seen this. These are for spouses of H-1B workers, largely from India and from China, who have huge backlogs and delays in terms of how long it would take the H-1B spouse to get a green card, to get permanent residency. So the Obama administration had created a regulation to allow these spouses to be able to work, to be productive members of the economy, not to have to sit around or to go underground. Over 104,000 have benefited from this. The Trump administration has announced their intention to take away this work authorization. All of this is impacting the employers who are sponsoring these people, as well as families who are losing their income, workers who are losing a large part of their reason for being on a day-to-day. L-1 visas, this is a huge area that received a ton of scrutiny under Obama. We're seeing a continuation under President Trump. These are for intra-company transferees, people working for global companies outside of the US at a high level, coming to transfer to work in the US. These applications, again, being challenged and denied at unprecedented rates. President Obama had put in place an entrepreneurial program for foreign investors who were going to come and set up businesses in the US, which would then hire US workers. The only way that a foreign investor would be able to benefit is if she or he could show that this investment is going to have a significant public impact to the US through rapid job growth and job creation. This was supposed to take effect July of 2017, just a few days before, President Trump officially delayed the implementation, and a week or two ago, they formally announced their intention to stop this program before it even has begun. NAFTA is another area where we're seeing quite a bit of talk in the immigration realm. As a candidate for the presidency, President Trump talked about renegotiating or eliminating the trade agreement between Canada, the US, and Mexico. He continues to talk about it. There is an immigration component that doesn't get nearly as much publicity or media attention as some of the other focuses, but the NAFTA agreement created the TN visa, which is for Canadian and Mexican professionals who are going to come to work in the United States in a handful of fields. The Trump administration wants to limit the number of occupations that are available, and these are lawyers, these are scientists, engineers, teachers. He wants to, and the US negotiators want to limit the availability, while the Canadian and Mexican negotiators want to increase and expand the number of occupations and not put a cap in terms of how many years someone can work in that status, which is what the Trump administration wants to do. We've already seen changes with economists in the TN occupation, where the government has limited the number of jobs and duties that they can perform. Major change that we've seen is the end of a long-standing deference policy, where in the past, if an employee was working for an employer, continuing with the same employer, same type of job, and they're filing a repeat application, if it was approved the first time in the absence of fraud or material error, the immigration agency was going to go ahead and approve the extension applications. The administration has now said we are getting rid of that policy. Every application is going to be treated as if it has never been sent in before, and it has the effect of forcing employers and employees to file massive applications where before it would have been much easier on them, and then challenging more applications than ever. We are seeing huge processing delays, no matter what type of application, whether it's in the business context, the family context, the humanitarian context. Slower processing times across the board is the name of the game under this administration. Again, this is having the impact of forcing employers and employees to ask themselves, is it even worth it for us to go through this process, which is exactly what the administration is hoping to do without having to go through Congress, which would be a much bigger task. We're seeing extreme vetting, which is really for supposed security and fraud prevention, whether it's at US embassies and consulates overseas, whether it's with the immigration agency in the United States. This is different agencies that are vetting applications in ways, more thorough ways than ever before. There's an in-person interview requirement before any employment-based green card application or applicant, someone who's trying to get permanent residency through their employer. In the past, those applications were reviewed on paper. Now they have to go in for an in-person interview. All of this is just delaying processes and making people question and wonder whether it's worth it. A couple of additional changes. This is outside directly, or outside of the employment context specifically, but it does have an impact because these individuals are workers and it's impacting the workforce. One would be the Muslim travel ban, or the ban that it has impacted a number of majority Muslim countries. That has been bounced around through the courts. We're waiting for a decision from the Supreme Court right now. The administration has tried to prevent citizens from a number of countries from entering the US, and when those are your workers, those are your family members, those are your community members, that has major changes and impacts. The government has announced a termination and phase out of DACA and TPS. That's the Deferred Action for Childhood Arrivals program, which has given protection from deportation and a work permit to young people, or to people who came to the country at a very young age, have lived their entire lives here. TPS is temporary protected status for citizens of certain countries that have had to deal with huge disasters, civil strife, El Salvador, Honduras, just to name a couple, Haiti. There have been about, really over 1 million individuals, when you factor in the approximately 700,000 DACA recipients, as well as a couple 100,000 of TPS recipients, who have work permits. And so if the government is taking these away, then that means that a huge amount of workers and employees will no longer be entitled to work. One small point is that congressional offices have always had a direct channel into the immigration agency, and the various immigration agencies that, or various government agencies handling immigration. They've been able to get tricky cases unstuck. They've been able to help out. They are seeing roadblocks now across the board. It is incredibly frustrating for them as well, just given the lack of responsiveness from the government. So what should employers do? Well, you have to prepare for the possibility of losing valued workers or not being able to sponsor key workers. Must be prepared for increases in worksite audits, investigations, make sure that all of your immigration paperwork is in order. Everything has to be started early because everything is taking longer. And for those employees, employers who are in a position to advocate and to push for sensible immigration change, that is critically important. And for the workers themselves, they have to be prepared to know that there's going to be delays, there's going to be stress, and it is entirely possible that things aren't going to work out for them. And that's on the legal side. If someone's here without permission, then really they need a change in the law, otherwise they're going to be out of luck. So in conclusion, just want to wrap up by saying that the hostility that we're seeing right now towards employers and employees really predates President Trump, but he is taking everything to levels previously unseen. And it just begs the fundamental question of how are we viewing foreign national workers? Are they security threats? Are they job stealers? Or are they valued employees who contribute to the economy and to their communities? And no matter what happens in the future, the bottom line is that it is going to take a very long time to undo the damage that has already been done. Thank you.
Thank you, Michael. So we're gonna shift gears and talk about affirmative action, and I'm gonna let Tim and Matthew take it away.
Sure, and much like immigration, I think the affirmative action area, the OFCCP, is also another agency where you could see a lot of changes potentially coming out of the Trump administration. Under the Obama administration, there was a considerable push in terms of to expand the role of the OFCCP under the executive order, and in particular focus on enforcement and equity in terms of pay. But before we go on those pieces, I'd like to ask Tim just to kind of give us an overview and kind of what he sees coming out of the administration on those pieces.
Yeah, so the first official initiative that came out under this new administration was just to that piece right there. We're going to focus, the OFCCP came out and said we're going to focus more on transparency, whatever that means. I think there was always been, in the contractor community, there's always been some lack of certainty about what exactly we're supposed to be doing. So that is supposed to be corrected through educational means and training. And they actually implemented a new policy where they're going to have, before you are found to have violated the law, they have to give you a predetermination notice that gives you an opportunity to respond and make sure that what the OFCCP is basing its decision on is correct. Because sometimes, and I'm sure, Matthew, you've seen the same thing, sometimes the data dump that gets pushed to the OFCCP isn't always an accurate depiction of what's going on. So I think that's a positive development. I still think there'll be enforcement. Obviously, the OFCCP, a big part of their activities is to make sure there's not instances of systemic discrimination. They're going to continue to do that. I just think there's going to be a little bit more oversight with respect to the regions in that regard.
Tim, just kind of a piece of background. So who is covered by the executive order?
Yeah, that's a good question. We've heard a lot during these last couple of days about extensive regulation and the impact that it has on business. If you're a federal contractor or a federal subcontractor that falls under the eligibility requirements, you have some additional requirements that are fairly onerous that you have to complete. And the idea is, for the privilege of doing business with the government, you have to meet these extra high standards. And so when we get calls from potential clients or businesses about whether they have affirmative action obligations, our first step is to really make sure that they are covered, because it's not as easy as saying, you don't wear a shirt that says I'm a federal contractor. A lot of times you don't get notified by the federal government that you are in fact a federal contractor. So there's some information. Typically the folks that are making a decision as to whether or not you have to comply with the laws are the HR department. They don't know where the money's coming from in any particular business. So that's one of the first things we look at. So the general rule is if you have a federal contract that is $50,000 or more and you have 50 or more employees, you are covered by sort of the highest level. Yes?
Can I ask you a related question? When are you a subcontractor?
That is exactly what I'm going on. So the question was, when are you a subcontractor? And that is a huge pit of misery for both the government and the contractor community. There's some case law out there that goes sort of very hard to sort of to figure out exactly what the rule is. But the statute or the regulation says that the subcontract has to be necessary to the performance of the federal contract. So if you're a plumbing contractor and you're hired to do all the plumbing work at a federal installation that's being built for the Department of Defense, it's pretty clear you're a federal contractor. They need plumbing there. But there's been all sorts of cases where just because you are being hired by a federal contractor, if the work that you're providing to the federal contractor isn't related to the federal contract or isn't necessary to the federal contract, you have the ability to say, we're not covered by this law.
What if you're a law firm providing legal services to the federal contractor?
Again, it would have to be, it would depend, there would be, I could see situations where you clearly would be a subcontractor. I know when we had, in New Orleans, we had Katrina, and there was law firms that were being hired to evaluate the claims that were being made, and some of that money was coming from the federal government, some of it was administered through the federal government. Those law firms were, at least for a period of time, probably covered by it. Now, I don't know whether or not they had affirmative action plans. They probably didn't. But for the most part, it is hard, and that's one of the things we evaluate with our business clients, that are you a subcontractor? And if you can make a colorable argument that you're not, the position is let's take that position, let's go forward, and if the OFCCP disagrees, then you can start complying with the law going forward.
In terms of those, are there, particularly with subcontractors, size requirements in terms of when I have to file the AAP, the affirmative action plan component?
Yeah, so that's the other big part of being a federal contractor. You have to do an affirmative action plan, and it's not just a snap of the finger and the thing is created automatically. There is a huge amount of work that has to be done, and you know, we struggle, some of our clients will struggle with the idea of implementing a handbook. This is probably a handbook, you know, times 1,000. And so you have to sort of go through the process of making sure you understand exactly what data has to be collected. There's things, for instance, under the prior administration, if you're a federal contractor, you have to ask all applicants if they're an individual with a disability. Now, anybody in the HR community knows that that is the biggest no-no ever. You can't do that. But the OFCCP says, no, we want to be able to track the number of applicants and the number of hires of people that have individuals. So as a corporation, you have to really make sure that you firewall that information away from anyone who's involved in the hiring decision-making process.
Just a related question, and having an expert here is able to ask it. What are these people that send you these unsolicited electronic requests for jobs? Are they applicants within the meaning of?
And that's a great question.
Repeat the question.
Yeah, the question is, so your obligations to start tracking information relating to race, gender, disability, veteran status starts when somebody applies for a job. Well, in the old days, when somebody, and I mean the old days, 10 years ago, when somebody would apply for a job, they'd walk in, fill out an application, hand it out, that was it. So much of job applications are being completed online. And so the question is, when is an application really an application? And the OFCCP came out with some guidance on that. It's extensive. It really is extensive. It sort of creates more questions that it really answers. But what I like to tell clients is, as soon as that what communication sort of is being considered for employment, that's an application, and so you have an obligation. So, you know, I would suspect, if you applied for a job at NYU and you did it online, the first thing it would kick to you would be you'd have to disclose you have the opportunity to self-identify your race, your gender, your veteran status, and your disability status, and then that information's collected, and then obviously when you're hired, you have to disclose the same information, and the OFCCP will have access to that, and they want to look at the statistics to make sure there's no potential evidence, potential claims that you're not hiring folks that fit within these categories, these protected categories, at a lower rate than would be expected statistically.
Which actually, the application piece is kind of an interesting component, because as technology is advanced, we're able to collect more information. We're able to store information longer. You no longer have a banker box full of applications. You now have a disk drive with it, or a drive somewhere. Well, what types of problems can that create for contractors having the access to do this with data?
Yeah, you know, one of the problems with data is you kind of dump it in there and there's really no way to evaluate it. And generally when you get the compliance, how compliance audits start is you'll get a pre-audit letter that gives you a little bit of notice that it's coming, then you'll get the actual audit letter. The idea is you're supposed to be getting into your records and figuring out what it looks like. It's sometimes very hard to do that. And so what ends up happening with a lot of companies, they end up sort of dumping the information to the government and letting them figure it out. And that's not always the best approach. So having too much data is a problem. And so we've seen some companies in conjunction, and this is one of the things that technology helps with, is that if you have some minimum standards that you apply across the board for a particular job, for instance, we're hiring a driver, and that person has to have a valid driver's license. Well, when they go through the application process, if they don't have a valid driver's license, they're gonna fall out of the process. That's okay, the OFCCP is okay with that. That person is technically never considered a qualified applicant for purposes of their tracking. And so the answer to that really is trying to use technology and work with some of these vendors, I think, that I've seen out there that can help you manage the data on the front end.
The other piece that we often see from the applicant side is you'll have companies that have, entry-level positions that are open all the time. If the position is open all of the time, there is no open date and close date on the application. So in terms of that, it's an ongoing application. So if I ask for, what positions were open, give me all of your applicants, because I never closed it out, all of those prior applicants who I really didn't consider for my hiring this month are still part of the applicant pool.
Yeah, and that's the, normally when we handle OFCCP audits, the first thing we're looking at is making sure that there's no evidence of a systemic discrimination case, and it's a statistical case. And so to do that, we have to have good data as to who really were being considered at the time. And one of the ways that companies do that is through a really good an applicant flow log. So anybody that's a federal contractor, you have to log in all sorts of information, but the whole goal of it is you're supposed to determine exactly when that person went into the hiring consideration pool and when they came out, and more importantly, why. It's very hard, particularly with the compensation focus, it's really hard to figure out why a decision was made not to hire somebody when you've got thousands and thousands of applications that are just sort of sitting there. It is very difficult for federal contractors. I would say easily the hardest part of being a federal contractor is developing an applicant flow system that makes sense, that people can keep up with and review.
So obviously a large part of the AAP is the data that's being produced and created for the OFCCP. When you're working with a client, what type of advice do you give them in terms of before submitting their affirmative action plan? Do you go through self-critical analyses? What types of things do you recommend?
Well, as outside counsel, obviously, we like to get called as early as possible. The reality is that's not how things normally happen. Normally, they get the letter, they try to compile the data on their own, and then maybe a week before it's due, then they call us. And so it's very difficult. We have good relationships with a lot of the field operations officers, and we can get extensions to some degree, but it's sometimes hard to do that. But if in a perfect world, we would get the call when they got the pre-scheduling letter, we would sit down with the client, we'd work through the data, and we would conduct, under the auspices of outside counsel, where we could maintain some privilege over the information, and we would evaluate the data before it goes to the OFCCP.
Which I think is an important piece. In part, that's one of the things that I do. But oftentimes when there is a notice of violation that comes in, and the first thing you start to go through is the data, and you find that there's issues with the data that was produced. Job groups weren't defined properly. You have people who were not in the right facility, so you could have multiple facilities that you're providing for. In terms of one of the aspects when we work with clients on the front end, I think of this as a data production, much like I would think of a data production in a litigation matter. It's going to be scrutinized, it's going to be used, and it's much easier to have it right going in than trying to correct it on the back end.
Yeah, it's the junk in, junk out philosophy applies here, and it's if you go on the OFCCP's website, you can see the settlements that they've entered into. These are hundreds of thousands of dollars, sometimes multi-million-dollar settlements that are based on nothing more than statistical analyses, not we just recently worked with a client on one where we settled it. It was an audit that dragged on for 7 years. There was no way that we could establish the reasons behind specific hiring decisions. So we were stuck with this prima facie case based on statistics, and we had no way of rebutting it through actual evidence of why decisions were made. And that's the reality of how it works in that world. So it is important to make sure that your data going in is good, to track it all along. And obviously, the whole point of the affirmative action program is to conduct a self-analysis of what's going on in your workforce to see, okay, if we have a shortfall of minorities in a particular job group, why is that? Or how can we correct that? What outreach activities can we enter into to try to attract more qualified applicants? Affirmative action is sort of a dirty word, I guess, when you go back to the origins of it. But the reality of affirmative action is it's not a quota system. It is about trying to make sure people have equal access to jobs, trying to make sure that companies are evaluating qualifications and experience in an objective way, as opposed to the subjective things that tend to creep in.
And just to wrap up, any expected changes out of the Trump administration with the agency?
It's hard under this administration to predict much. There's a lot of sort of bluster that comes out, but then when you look at really what's going on, the changes, and again, it's not just the OFCCP, any of the agencies, the changes tend to be a little bit more incremental, a little bit more typical of what you'd see when a different party comes in. So I don't think there's going to be any sweeping changes. I know there was some discussion about merging the EOC and the OFCCP. That has pretty much, from what I can tell, been sort of shot down. It was not something that either the contractor community or certainly the EOC or the unions that they were in favor of. So without support of those groups, you're not going to get a big change like that.
Great, thank you very, very much. So now we're going to shift over to using artificial intelligence to evaluate employment law decisions, and Charlotte, you're going to start.
Great, thank you. So I will pivot from Sam's question, when are you a subcontractor, to discuss the question of when you're an employee. So the work I'm going to talk about is actually drawing from 2 projects. And the current project is the one that uses data science techniques, and so is considerably sexier than the prior one, which replicates, I think, what some of the current, or I think it was Chair Ring who was talking about sitting in a room looking through decisions and trying to manually understand what was going on in decisions. So we're shifting, in my own research, we're shifting from a world of reading lots of decisions, lots of legal documents, and trying to extract insight from them, to being able to apply the tools of data science, including artificial intelligence, to try to extract insight from legal text. So that's what I'm going to talk about a little bit, the methodologies, but the subject is one that is of interest to those of us who are in the employment and labor law world, which is this question of employee classification. And it's of particular interest to the U.S. Department of Labor because they gave me $250,000 to study this subject, not just me, but a collaborator of mine as well. That was under the prior administration, and given that we're talking about the current administration, they haven't rescinded that money, so please, I hope they don't. But this springs from an initiative in the Obama DOL that is focusing on this question of employee misclassification. Okay, so I'll attempt to string together all of these strands, employee classification, AI, and the DOL's interest in this. So the previous project I mentioned, I was interested in looking at the data as it existed at the time that tell us something about which categories of workers are most frequently misclassified as a status other than employee, when you would expect perhaps them to be properly classified as employees. So as you can imagine, that's a really hard question to try to answer based on data, because by definition, these folks are in a classification that is probably not accurate or possibly not accurate. So you have to figure out how to get beneath the independent contractor classification that they might have and say, well, this subset of independent contractors actually should be employees. So that's a big challenge. There's a guy at the Census Bureau who has a paper, it's quite old now, in which he compared workers' own classification of their wages and their job status that they gave, their classification that they gave to the census takers, to the classification that their employers gave them in the Social Security data. And so because he worked for the Census Bureau, he could actually match individual real people by their name and Social Security number, so he could say, for example, this person got a 1099 and is recorded as such in the Social Security data, indicating that they are not an employee for tax purposes, but here their own response about what they do for a living indicates that they are an employee on this other survey. So by pretty ingeniously, I think, matching up those two sets of responses, this prior research was able to identify occupations in which it seemed like there was a misclassification problem, where the worker on the one hand said, I'm an employee, but the data provided by the employer says this person is an independent contractor. So I was then interested to see, well, which subset of these highly likely to be misclassified workers actually go to court to challenge their classification, and what happens to those cases. So employing the types of strategies that I talked about, that John Ring talked about, where you sit there, you read a lot of decisions, a bunch of law students and I put together this schema. So we were interested in who's misclassified, and then for this project we were specifically working on Title VII or discrimination cases. Within those cases, who's going to court to challenge their classification, and then what happens? Which of them make it into the employee status bucket when they've challenged their classification as an independent contractor? So what you can see first in filling in that first circle, who is highly likely to be misclassified, these were the top 15 occupations by the numbers of workers misclassified. So we won't spend a lot of time going through this, but you can see at the top you have real estate, realtors, but as you work your way down, you see some sort of lower skilled, lower paid jobs. Well, I don't mean to, lower skilled, I don't like that term, but lower paid at least, occupations lower down. So maids, construction laborers, et cetera. Note the very bottom category, physicians and surgeons. Often that happens where a doctor is working at a hospital and there's some dispute about whether he or she is employed at the hospital or as a contractor. You may be familiar with this from getting insurance bills from, the hospital and the doctor, right? So then, though, when you go to court decisions, right, who actually goes to court to challenge their classification, look at what the top category is there. It's physicians and surgeons. And where are the maids, right? Where are the construction laborers on this list? They're not there. And this probably doesn't surprise those of us who think about, what it takes to go to court. If you've been a plaintiff's lawyer, as I was before I was a professor, you know that it takes a lot for a plaintiff, particularly a low-wage worker, to stand up against their employer and to pay the costs of going to court. So I think this is perhaps an unsurprising result, though perhaps a depressing result for those of us who care about access to justice. But my next question that I was interested in is what was happening to these misclassification challenges in court. And 66% of the cases that we studied, there was the plaintiff lost their challenge, and so the judge said, actually, you are an independent contractor, and that classification was proper, so now go home. 34% of folks won. But we didn't just, when we were doing this manual process of reading and processing these decisions, we weren't just looking at win and loss and outcome, we actually pulled out a whole lot of features or characteristics of the plaintiffs, the defendants, the claim types, the judges, et cetera. And so we were able to run some regressions to identify variables that were associated with plaintiff wins and plaintiff losses, controlling for everything else that we could hold constant. So here we see this doesn't tell us anything about effect sizes or anything like that, but we see that the variables that were positively associated with plaintiff wins, right? So the folks who had attorneys who specialized in employment law tended to do better. So nice for the plaintiff's bar there. There were circuit effects, right? So in circuits that had some more favorable case law that seemed to play out. But then on the flip side, the variables that were associated with plaintiffs doing not so well, particular fact patterns fell out of the data there. And then, but the one I want to spend a moment talking about is when there seemed to have been a written contract that labeled the worker as an independent contractor, that particular variable was highly predictive of the plaintiff being found as to be an independent contractor by court. And maybe that's just a proxy for some of other facts about that putative employment relationship. Or maybe what we're seeing is judges sort of doing a shortcut. And actually, when we got into some of the text of the decisions in more detail, there were actually several that we found where the judge is saying, oh, well, if you agreed in writing that you were an independent contractor, ipso facto, you're an independent contractor. Well, which is, of course, not the way the analysis is supposed to happen at all, because an employer can ask the worker to sign a sham contract, right, which labels him or her an independent contractor. And the whole analysis is supposed to set aside the label that the relationship has been given by the parties and instead look at the underlying facts. So I found that to be troubling, or perhaps more mildly intriguing, what was going on here in those decisions. Okay, so that's the previous project that I did that used entirely manual classification techniques and was really only focusing on a very small set of decisions. So what I'm working on now, which the Department of Labor is funding, is doing a similar type of process, but using advances in text analytics to delve into a much larger set of judges' decisions. So we have about 12,000 decisions that deal in some way with the employee independent contractor distinction that we've gathered from all U.S. district courts over a 10-year period. And I should say the prior project focused only on decisions that showed up on Westlaw. What we're doing is trying to cast a wider net, and we're going straight to PACER. We're going to all different sources we can find to make sure we're capturing not just the decisions that make it into Westlaw, but decisions from all sources. So we can really try to cover the waterfront. And so here we're interested, we've dropped out the first part of the prior project, which was kind of looking at who's misclassified as best we can tell, and then who goes to court. But we're really focusing in on what is happening in the court. So how are judges drawing this line between employee and independent contractor? What's the profile of the misclassification plaintiffs and defendants in these cases? And are there certain factors in courts' analyses that seem to be driving the outcome? And we hope we might be able to build a model that could predict outcomes. We'll see. So like I said, we're just sort of focusing on this question of which plaintiffs make it into the employee status bucket and why, as best we can decide from the judge's decisions. So just in a nutshell, this is just to try to illustrate to you what the process is. So if we have a judge's misclassification decision, this one is actually from the Southern District of New York. Some of you may be familiar with it, Rick's Cabaret. The question here was whether there are dancers, exotic dancers in a club known as Rick's Cabaret that had been classified, who had been classified as independent contractors. And they argued that they were in fact employees and therefore were owed many protections that employees receive under the Fair Labor Standards Act and New York state law. So this was the judge's summary judgment decision on this. And if you know this case, you could probably just look it up and read it, and you could learn, okay, well, the plaintiffs won here, and it seemed like the judge spent a lot of time focusing on this part of the analysis. Well, what we're trying to do is do that analysis across 12,000 decisions without having to read them all. So one set of information we might want to get from these decisions is, well, what's the profile of the defendant? What industry is the defendant in? And what's the occupation of the plaintiff? And so to do that, you have to identify the words in the decision that tell you that. And so we're working on code that actually looks for words that are indicators of occupation and words that are indicators of industry and pulling those out. We are also classifying or categorizing the decisions by the statute under which the claims are made, because this is not just focused on an FLSA-focused project. This is focused on all instances in which the classification question comes up. So here we have code that pulls out every version of every statute, including full name, abbreviation, and citation, and then we can, from that, derive some statistics. And then we're also interested in things like which test is the court applying. So if you are familiar with this area of law, you know there are different tests applicable to different statutes. The different circuits have different versions. They're all multifactorial. It's kind of a big mess. But you can try to, we are working on pulling out indicators of which test the judge is applying in resolving the dispute. And then in this case, here's the language that tells us who won. So the court comfortably concludes, as a matter of economic reality, that the dancers were employees. And then the judge here sort of goes back through the particular factors that seem to be most important. So opportunity for profit, control, et cetera. These are all factors that are enumerated in the Second Circuit's test. And interestingly, the second bit of highlighting, the court soundly rejects this argument that there was an agreement between the parties that labeled them independent contractors, right? Contrary to what I was mentioning from my prior project, where I found some courts seem to just sort of rubber stamp a contract or agreement that was between the parties. And so then the challenge for us is to find within all of these multi-page decisions the piece where the judge says what the answer is. And when I work with a lot of my data science colleagues, it blows their mind that there's not one standardized part of a judge's decision that says, well, here's the answer and here's why. And I have to explain, yes, well, you know, we're all individuals and we're all great writers, and you know, we don't follow a checklist, right, when we're in our legal system. So this is quite a large challenge, and I'll show you some preliminary results as I close. The other thing I wanted to say we're working on is pulling out all citations to case law so we can develop a sense there of which precedent judges are relying on and how often they cite different cases to get a sense of which seem to be motivating their decisions. Okay, so some quick preliminary results. We only have 48% of these 12,000 decisions that we've worked on so far, because this is still a work in progress. But of those, pulling out the statutory citations and the names of the statutes, again, perhaps unsurprisingly, the most common claim type is an FLSA claim type, followed by Title VII. The interesting thing that I want to explore here is the ones that don't fall into one of these employment law-related buckets. Either that's because we need to work more on them to make them fall into one of these buckets, these unclassified cases. But also there are IP cases in our data set where the arguments are actually going the other way. So the worker wants to say, I was actually an independent contractor when I worked for you, and so I have ownership of the IP, whereas the company is arguing you're an employer and your IP is mine. So what I want to see is how are these analyses different, or how are the outcomes different when the worker is making the opposite argument to be an independent contractor rather than an employee. So, but we're not there yet. The other preliminary results that we've been looking at is which keywords and phrases are being used with different frequencies in these decisions. I think there's something weird going on here. I think this is actually pulling in the word contractor. So again, this is preliminary. But what this is a word cloud where the size of the word indicates the frequency with which it's used. And the way we have it set up in this dashboard is you can click on different courts and you can change the slider to isolate a particular time period and get a sense of which words and phrases are being used most frequently in the set of employee misclassification decisions issued by that court in that year. And we're going to add a whole bunch of other features to this where you can isolate different claim types, judges, legal tests, et cetera, to get a sense of the patterns going on. And we'll do a similar one with case citations. And so the goal is, in closing, is to do this not only for the Rick's Cabaret case I mentioned, but to do it across all 12,000 decisions so that from this we can derive a picture or a portrait of how judges are resolving employee misclassification questions in all contexts in which they arise, and then to see if we can do something pretty neat and predictive, so we can say, given X, Y, or Z factor that you put into the equation, what do you expect a judge to do on the back end? And so that's what the DOL is interested in. They're interested in knowing what's going on in the courts in this relatively murky area of law. I'm interested to see if some of the findings from our earlier project are replicated in this one. And it's just super fun generally to try to test the application of these data science techniques to legal documents, because as those of us who are lawyers know, this is coming and it's coming big time. So we're trying to see what we can do in the employment, in the area of employment scholarship. So thanks very much.
Thank you, Charlotte. Okay, we're going to turn to Destiny, who's going to speak about AI in disparate impact cases.
So I took Professor Estreicher's class in the fall of 2017, and there was one question that he repeated often, and he wanted to know how exactly are employers using artificial intelligence when making hiring decisions. He repeated the question often, and so I thought to myself, you know what, I'm gonna try to answer it. So I went online, I went onto Westlaw, I printed out about 10 academic articles and said, look, professor, this is how they're using it. And he said, you didn't answer my question, right? These are still hypotheticals. These are still ifs. These are still possibilities. I need to know the hard and fast evidence that shows me how employers are using what we all know that they're using. So that's what I ended up doing. I don't have all the answers, but I do have some evidence that I think you'd be interested in. So I hope by the end of this talk, you'll understand the opportunities that you all as lawyers have to figure out how, and not only these four pieces of evidence that I have to offer you, but the areas where you all can kind of enter into the atmosphere to really shine light into a black box of information. So I have to mention that the question was timely, because it was about the time that Cambridge Analytica happened. We were asking ourselves how, in fact, does Cambridge Analytica have the ability to gather so much information about us and then use it in order to, apparently shift our own political, proclivities, right? And another attendant question is, if they can do that with politics, how else is information being used? Who else is information being given to? We know that information usually is given to marketers, but in fact, this type of information is also given to employers. There's three ways that I want to approach how we can understand artificial intelligence in the employment making process. And in the end, I want you to understand how, in fact, disparate impact is happening. First, I'm going to begin with what exactly artificial intelligence is in the employment context. Second, I'm going to offer you the 4 pieces of evidence to show you that, in fact, employers are committing disparate impact. And then finally, I want to make 2 suggestions, but really open questions about how we move forward using this information. So the first part is the actual decision-making process. There are 7 parts to it. I'll walk through them very quickly, but it's really to help you understand the gaps that allow employers to potentially do some untoward things, intentionally or unintentionally. The first step in the employment-making process when using artificial intelligence is to collect your data. And so there are 3 primary sources of data. You have your employer himself or itself. You have previous employers, information based off of previous employers, information based off of previous employees, current employees, as well as information on those applicants that you rejected during the hiring process. Another source of information that you can collect is from data brokers. So data brokers, you might be familiar, simply scrub the internet for information on particular job candidates. So some of this information that data brokers can collect can include some of your professional interests, or your criminal history, or your bankruptcy filings, or how you browse websites, or if you've done some online purchasing recently, your cookies can save that information and data brokers can use it. It also can include who you follow on social media, your likes on social media, any groups you're a part of. It can include information about your previous employers, any hashtags that you use on Twitter. And so you can imagine when you compile all this information, the type of personality profile that can be made that's subsequently given to employers. And a very interesting part of this data collection by data brokers is that they actually label you before giving this information off to marketers or people who want to sway politics, or to your potential employers. Some of the labels that they use, and I only found a couple, are pet owner, people who do not speak English and feel more comfortable speaking Spanish, single mothers struggling in urban setting. So these are actual labels that your data brokers will use before selling it off to parties who are interested in information. This information can be as specific as you, or it can actually be more macro, right? So it can be based off of travel patterns that Uber might have, their information. So it may not be person specific. Then we have the third source of information. Those are your vendors. Vendors are, also, I'll mention a few. One is Evolve, another one is IBM. But vendors are simply people who create the algorithms that are sold off to employers that they can use to make their decisions. So after your data collection happens, step 2 is your compilation. So put all those 3 together. And then you have your step 3. Step 3 is simply descriptive analytics. So it's an attempt to understand the existing data that I just mentioned. It's an attempt to understand the hours worked, per employee. It's an attempt to understand how the number of years that you spend in school can affect your performance. It's an attempt to understand how many social media accounts you have. Then you have step 4, which is defining your target variables. This is when an employer asks itself, what does my ideal candidate look like? And so they might say to themselves, my ideal candidate retains at a rate of 85%. Or my ideal candidate actually has a customer satisfaction rating of 90%. So after defining that, you move to step 5, which is simply to have your AI-based predictive analytics. So you input the data into your algorithm, and then the algorithm also uses those target variables, and then it simply spits out predictions, right? So we predict, these are hypotheticals, but we predict someone who only takes 2 hours off a week from work, or per month from work, has higher customer satisfaction ratings. Or we predict that someone who only has one social media account is productive at a rate of 90% or higher. Remember, these are correlations. These are not causal, which actually goes to a root of the problem as well. We'll discuss that in a bit. Then you have your step 6, which is the prescriptive analytics. Prescriptive analytics simply is when your algorithm, or your vendor who provides the algorithm, tells the employer, based off of the predictions that we've made, that are based off the data that you provided us, and that vendors provided us, and that data brokers provided us, we think that people who fit these particular categories will meet your target variable at a particular rate. And then finally, your employers will take the prescriptive analytics and use it to make their hiring decision. Remember, of course, as you all know, that employers are the final word. Even though a vendor might color code a particular candidate based off of the information, employers make the final decision. So the benefits, you know what they are, so I won't discuss those. But there are a number of risks, right? To summarize the risks, because we have a limited amount of time, is simply that bias is encoded in all parts of this, right? Bias can be encoded in the data that's put into the algorithm. Bias can be encoded into the source code that makes up the algorithm. Bias can be encoded in the target variable that an employer chooses. Bias can be encoded in how the employer chooses to use the actual predictive analytics. It's everywhere. Now, to go to Professor Estreicher's question, right? How do we move beyond the hypothetical, right? The opportunities for disparate impact to prove that it is actually happening, especially considering that to date, no plaintiff No person has brought a case against a company for disparate impact, right? No organization has done so. So there's 4 pieces of evidence. And quickly, 3 of them are interviews that happened in 2013, 2014, and 2012, and 1 is a patent, one patent of many. So in the first interview, you have a woman named Terry Morris from Xerox. It's in September 2013. It's actually a blog post. And in the blog post, she says one thing that is particularly interesting, and I'll read it. She says, "So who is the ideal customer care worker? The data tells us it's someone who lives close to their place of work, has a reliable source of transportation, uses social media, but not too much, and is creative." So I'm sure there's probably light bulbs going off in your head, right? To live close to your place of work is to imply, I have 2 minutes, I will hurry. To live close to your place of work is to imply that, well, depending on where Xerox office is, that you have a certain amount of income, right? To have a reliable source of transportation, well, that one is obvious as well. So the second interview not only confirmed what Terry said, but went on to say that Terry actually said, quote, "We're getting to the point where some of our hiring managers don't even want to interview anymore. They just want to hire the people with the highest scores." And that's a 2013 Atlantic article. In the same article, I have to point out, there's a vendor named Evolve. This is a vendor that Xerox used at this time. They actually said, quote, "Evolve simply won't use certain information. Some of this information includes the distance an employee lives from work, because different neighborhoods and towns have different racial profiles." So in the same article, you have both a customer and a vendor providing really, opposite information as far as their use of it, and that is particularly peculiar to anyone who would read that article. The third and final article is a 2012 Wall Street Journal article where Terry Morris confirmed her use of it, or Xerox's use of it. But then also, IBM has their own, they're also a vendor, and their particular company that provides these algorithms is called Connexa. And so in this particular Wall Street Journal article, they say that call center and fast food employees that have longer commutes or who frequently relocate receive higher scores when they're giving their information to the actual customers that use the algorithms. Again, those things can pose really interesting questions. The final piece of evidence is an adverse impact patent. So after hours of research, I found that there are about 200 to 300 patents that actually that patent the algorithms that vendors are using. But there was one that was different than all the others, and that was one that attempted to reverse adverse impact that was happening. This particular patent was actually approved in October of 2017, so less than a year ago, by HireVue. And just to mention, HireVue, some of their clients that are using this adverse impact reversal model include Ocean Spray, Unilever, Urban Outfitters, Hilton, Dunkin' Donuts, Geico, you name it. Those are HireVue's clients. Now, I want to move to the very final question, which is how exactly do we move forward, understanding that there's evidence of employers using this information in a way that will adversely impact protected classes. There are 2 ways that we can move forward, right? The first way is to think about it from the defense side. How exactly can we prove that this is a business necessity? Because we have to understand that this particular technology is here to stay. It's not going anywhere. But a particular question that's going to have to be answered is what arguments can you make in order to prove that it's something that you can't do without as a business? The other way we can move forward is to consider it from the plaintiff side, right? How exactly can we make out a case in order to really get the black box of information that employers and vendors have with these algorithms, to open it up so that we understand how the source code is being used, so we understand the kind of data that's going in. So just in conclusion, those are 2 different areas in which you can really, I think honestly there's a potential source of litigation, because we can't rely on Congress to do so, and we can't rely on the EEOC because they've shifted course and focused on sexual harassment. But what I will say is that right after the sexual harassment wave has come and it's gone, and solutions have been made, I absolutely believe the next wave is going to come with artificial intelligence in the hiring context. Thank you.
Thank you. So I think we have time for maybe 1 or 2 questions from the audience. Anyone? Oh, yeah. Comment.
Just on that last point, millennials tend to use social networking far more than everyone else. Is there some sort of, is it both in the time spent, if they're tracking time spent on social media, but also just the content? Is there some sort of disparate impact with millennials, or almost a shift toward baby boomers who aren't using it, and so companies are thinking they're more reliable?
So I guess in order to answer that question, you first have to move back to your definition of protected classes. So millennials are not a protected class, right? So is there a potential adverse impact still? Absolutely, right? Understand that all of your information, and I say adverse, I don't mean in the legal sense, but are you being negatively impacted? Yes. All of your information that's publicly available is being collected by data brokers, right? If you think about just, I think this past week, Facebook, we learned inadvertently allowed people to share information publicly as opposed to privately, right? For, I think, I want to say 5 days or so, right? And that's just one piece of all the information that's being collected on millennials, right? So is there some type of negative impact on millennials more so than others? Possibly, right? Not possibly, there is. But I don't have anything in particular to say that, but I imagine so, yeah.
Okay, next question. Thank you, Destiny. Is there another question? I thought I saw hands up before.
Destiny, can you clarify?
Yeah.
Are employers relying on this stuff standing alone in making hiring decisions? Or are they using it as an input, but engaging in other? That's the question I have, because disparate impact will be evaluated based on the results of the hiring process.
Yeah. So the question is, are employers using AI as a shield, if you will?
No, as the one factor.
Screening list. They're using this.
Input among other inputs as well into hiring decisions.
Mhm.
Are they saying if you flunk, you don't have the various predictive criteria we're looking for, we're rejecting the application?
Good question. So the inputs are one of many inputs that are put into it. Now, of course, for each of these inputs, they're weighted at different levels. So, for example, I heard a story from someone at the EEOC who simply said she had a friend that applied for a job, and within seconds she got a rejection letter, right? So I imagine that some piece of information that was in her application was weighted rather heavily by her particular employer and spit it out, and spit her application out. Now, I will say that, I don't know if that answers your question. Did I answer your question? Okay.
Any other questions for the panel?
Can I just add one thing to
Yeah.
what Destiny was saying? At the end, Destiny, you were saying we need to open up these algorithms and see what's going on. Well, when a lot of these are unsupervised, meaning either truly in the sense of machine learning or artificial intelligence, we don't even know, right, what it was that produced that particular
Absolutely.
outcome.
Absolutely.
And nor does the person who designed it, because they're designed to take in additional information, update, learn, and so I think that there's a lot that that's going to be challenging our assumptions about how or the pre-existing structures around disparate impact, where we may not even be able to answer the question Sam raised, which is, well, yes, this AI result is one factor among many, but what was the factor that drove the AI result? We don't know.
This is true. The one thing I will add is that I think a part of the reason why employers and vendors have been able to go a decade without being regulated is because they use this idea that it is a black box of information to protect them from regulation, right? So, when there used to be paper applicants, I'm sure employers had notes. You could go back and look at it maybe to figure out why a particular decision was being made. Ultimately, the fact that it's a black box of information that can't easily be picked apart is not a reason why it should not be regulated, right? But technology companies, employers have used this argument successfully for about a decade, but it should not be the reason why we can't move forward. And that's why I think that litigation will be the answer. Plaintiff side litigation will be the answer.
Okay, thank you. All right, one last question. Yeah. Wait, is there a mic? Yeah.
Yeah.
Just,
Yeah, go.
oh, no.
My name is Yasmin. I wanted to ask, how do you think we as the American people can move against Trump actions as the immigration workers? How can we help them?
Sure, I could talk for hours and days, and I know everybody wants to get to lunch, but in terms of what people can do who care about immigration and are not happy with the direction that the country's going in, there's so many different ways. It's supporting grassroots movements, it's trying to take political advocacy to the next level, it's trying to put coalitions of employers and employees together to argue before those who are in power and in positions to make changes that things are not going in the right direction and that they need to be different. There's so many different things. Not one thing is going to be the magic bullet, but everybody who cares about this and so many other issues really has to get active and involved.
All right, on that note, please join me in thanking this terrific panel.